Ladies and gentlemen, and welcome to the Knowledge Group webcast entitled Artificial Intelligence in eDiscovery, a Productivity Revolution for Data Collection, Processing, Review, and Production. I'm Tom LaPointe, publisher at the Knowledge Group, and I'll be your moderator for today's event. We're going to go ahead and get right to our speakers. However, I would like to point out that on the next few pages, you will find useful information regarding some of the mechanics of today's webcast, as well as participants and company information. Please feel free to review these pages and refer to the Frequently Asked Questions tab to the right for answers to the most frequently asked questions. You are going to be getting secret words, which I'll be giving out, 3 per credit hour. You're going to record those secret words into surveys that are going to get emailed to you during the webcast. We recommend that you write those secret words down on a piece of scrap paper so that when the event is concluded, you can fill those surveys out and you have those secret words. I'd like to thank the motivating partners firms for this event. We have ZyLAB and Bird&Bird. Please feel free to visit their respective websites for more information. Our 2 speakers today are Johannes Scholtes, who's a PhD. He's also the Chairman and Chief Strategy Officer at ZyLAB, and he'll be going first. We also have Dr. Alexander Duisberg. He's a partner at Bird&Bird, and he will be speaking second and back and forth with Johannes. So we're going to have them, and they are invited to say a little bit about what they've been up to or interesting things about their companies as soon as they go on. We're going to turn the conference over to our speakers in just a moment. However, I would like to give out that first secret word to minimize any disruptions. The first secret word that attendees only, not speakers, attendees are going to write these secret words down, likely on a piece of scrap paper, and fill them into the surveys afterwards. Secret word number 1 is intelligence. Secret word number 1 is intelligence, and these are for surveys and ultimately CLE credits, as that's what you are seeking for today's webcast. Well, I'm going to turn the conference over to our speakers. I'm going to ask the rest of us to turn to page 9 to begin. Speakers, please go ahead.
Hello, yes, thank you. This is Johannes Scholtes from ZyLAB and from the University of Maastricht. I'm very happy to be here together with Alexander Duisberg. So together from Bird&Bird, together we're going to talk today about how artificial intelligence causes a productivity revolution in eDiscovery. And yeah, all of the participants have probably heard a lot about artificial intelligence, the successes, machine learning, robots, robot lawyers, robot judges, and we're going to talk today about, next slide please, about a little bit beyond the buzzwords. And I'll start, and then Alexander will take over halfway, and then I will take it over from him again. And we'll probably also have some short discussions when going through the slides. So what we're going to talk about today is how new techniques from the fields of data science and artificial intelligence can benefit the application of eDiscovery. And then in particularly litigation, but also dealing with regulatory requests or preparing virtual data rooms in M&A, and doing this faster, easier, and also much better. What we're focusing on today is how these tools can help us to directly collect data from various data locations, including Microsoft Office 365 and Exchange and SharePoint, where most of the data often is related to eDiscovery. But we're also going to talk about how deep processing can make every individual component of a large data set searchable, regardless whether it's text, the format, the language, whether it's audio or image, and how we can then use all kinds of automatic techniques to aggressively call data volumes without getting in trouble or being accused of data spoliation. We're also going to talk about advanced search, text mining, topic modeling, machine learning, and how they can be used for early case assessment. And in the context of eDiscovery, everybody probably knows the terminology like predictive coding and technology-assisted review, or TAR, which are used as the ultimate review accelerators in eDiscovery. And they also show over and over that the quality of the review is much better by using these techniques. And we're going to show you how this can be done and why this is done. So one of the important new things we're going to talk about today is also GDPR, because the GDPR, which is up in effect next year, will bring a totally new dimension to eDiscovery, information governance, but also to virtual data rooms in M&A. And we're going to talk about the implications and how we're going to deal with this. Next slide, please. So the goal of today is threefold. First, learn how we can deal with the disruptive effect and cost of regulatory requests related to antitrust, competition fraud, bribery, environmental, healthcare, financial, export violations, and the often very disruptive subsequent internal investigation. We're going to look at how this can be done in handling merger and acquisitions, and then in particular the preparation of virtual data rooms for large and complex deals in the field of real estate, refunding, venture capital, where there's a lot of collateral and a lot of documentation that needs to be checked. And then we're going to talk about how we can effectively take the new requirements of the GDPR into consideration and also deal with them in as much as automatic way as possible without having to do everything manually. Next slide, please. So why should we care? Well, it's the usual suspects. Data volumes continue to explode. We see it really every year. Data volumes double, and it continues and continues and continues, where we see new types of data, we see multimedia, social networks, bring your own devices. The cost of eDiscovery for all the different use cases we mentioned continues to explode, and new regulations like the GDPR, but also cybersecurity requirements, only adds additional complexities. And then we see that regulators are getting more and more enthusiastic, especially outside of the United States. In the United States, they've always been pretty enthusiastic, but these days we see that also in Europe, regulatory agencies are doing more and more investigations, and they have learned a lot from U.S. regulators, and they seize a lot of data, and they use all of the eDiscovery techniques as well. Next slide, please. Now, one of the problems with eDiscovery that we see is that that you never really know in advance what you're going to get. You never know how much data you will have. You never know what type of data it is. Is it images? Is it text? Is it Chinese? Is it German, English? Is it PST files? Is it Lotus Notes files? You never know exactly what workflow and iterations you have to do. And we also see that the only way really to deal with this is by using automation. But one of the problems is that this automation, in particular artificial intelligence and data science techniques, are very CPU and computer memory intensive. So you need to have like an intelligent and extremely automated load balancing and resource allocation system to prevent bottlenecks and to effectively deal with what we call the eDiscovery data wave. Now, with the ZyLAB architecture that we've developed, we can infinitely scale up the amount of resources we need. We use cloud architecture, very elastic architecture, where we can, without reinstalling the software and without redeploying the data, add hundreds of CPUs and cores and machines to the same configuration, or the same cluster as we call it, and then very quickly spin on new machines, increase the speed and the capacity of the system for the processing, and deploy those machines that we need for a specific type of processing. And then once we're done, we can shut down those machines. And one of the great things in, for instance, Microsoft Azure, is that you only have to pay for this hardware when you need it. You don't need to deploy huge computer and resources in your basement where you want to deal with peak performance, or you're being prepared for peak requirements. And we see that our clients love our flexibility to scale up, in especially in the Azure environment. Now, this may sound a little scary because the cloud is a sensitive spot to store data. But one of the other beauties of Microsoft Azure is that you know exactly in which data center your data is and in which jurisdiction it is stored. So if you want to make sure that your data is not being stored anywhere outside of Germany or the Netherlands or Europe or Canada, then Microsoft Azure guarantees that. And so you don't have to worry about that, contrary to other cloud services like for instance, AWS or Google. Next slide, please. Like I said, one of the totally new requirements, it's not totally new, the European Commission talked about it for a long time, but it got approved recently. Next year it's in full effect, is the GDPR. And GDPR has kind of a dual face, and we'll talk about it a little bit later. But there's a huge impact for the eDiscovery industry beyond the impact it already has to a lot of companies and organizations, which Alexander will talk about. Because what we see is that eDiscovery providers, such as law firms or vendors or other service providers, can be considered as data processors in the sense of the GDPR. And this has a lot of results, a lot of consequences. So that's the one part of the GDPR. The other part is that eDiscovery technology is an essential tool to be compliant with the GDPR. So we can also use eDiscovery to solve a lot of GDPR problems. And with that, I'd like to go to the next slide and hand it over to Alexander.
Yeah, well, thanks, Johannes. And this is Alex Duisberg. Pleasure talking to you today. I'm in private practice now for the last 20 years, of which the last 30 years at Bird&Bird, which is a law firm which is essentially focused on technology and the way technology is transforming our world, the worlds of our clients. And I think the topic we've chosen today around eDiscovery, so very much at heart of what we do in M&A and disputes, is chosen excellently well. We're right at the crest of the wave of seeing how the world is transforming. Now, the GDPR, the General Data Protection Regulation, Johannes already gave an intro to this, is a very large piece of new law which is coming into effect next May, and all companies, corporations, clients we are seeing are preparing heavily to align their internal processes towards GDPR compliance. Now, when we look at what we're talking about today, we can see that the effect and impact GDPR will have on running these types of processes is massive. And I'll talk you through a few observations which will kind of set the scene why this is so relevant, and then ultimately it's better to understand why solution providers such as ZyLAB can be of essential help in making these programs and these processes efficient and compliant with the law. The big thing about the GDPR is it is a regulation, which means under European law, it is direct, effective law at the member state level, in difference to the directive that we had in place for the last 20 years. If you think about 1995, when the European Data Protection Directive was put in place, that's about the Stone Age of data law. So 20 years afterwards, we are now ready for something new, and it is intended to achieve the following: a fully harmonized framework throughout the EU with an extended application, we'll look into that in a second from now, and taking data subjects' rights more seriously than they have been in the past, including a very steep increase of level of enforcement. And we've just pinned down here the top line of potential sanctions reaching up to 4% of aggregate annual turnover of any group of companies. So if you talk to Coca-Cola, General Electric, Allianz, Shell, any of the companies of major or also minor size, that is a lot of money which could come about if you don't get it right under privacy laws. If we look at the next slide, we can see that GDPR will apply abundantly. So it is obviously related to processing personal data by automated means. Anything that happens electronically, in simple terms, will trigger the applicability of GDPR. And the territorial scope is very interesting as well. In the past, we only looked at where a so-called data controller would reside. The data controller is the legal entity that defines the means and purposes of processing personal data. Now we're also looking at the term of establishment. This could reach even into situations where you have a U.S. company or another company that doesn't have a foot on the ground in Europe, but is actually operating within the EU, for example, just by technical means, a technical installation that is collecting data, or also doing so then effectively outside of the EU if the data subjects are resident in the EU and that company is offering goods into the EU. So you have a wider scope. And if we look at the next slide, I think it's very important to understand that personal data from the EU perspective is a very, very wide definition. It is actually much wider than what our colleagues and clients understand in the United States as PII, personally identifiable information. That could be more narrow, whereas personal data under the EU can be anything that potentially allows to identify a living person. And you see I've selected a few examples, including IP addresses. So just the tagging that you have by skimming through the web could potentially be deemed personal data. In addition, we know that particular categories of data deserve particular attention. And you could think about information about racial or ethnic origin, political opinions, religious or philosophical belief. Well, let's just stop on religious belief. You think that's trivial? Well, it isn't, because anyone who rolls a payroll service, for example, in Germany, for tax reasons, needs to indicate the religious belief, because we have a church tax that applies. So all of a sudden, you're kind of running or analyzing an inventory of payroll data, and you're actually in the reach of dealing with special categories of data, as well as genetic data, biometrical data. You're skimming through security control systems, and you're dealing with that type of information, which triggers additional need for safeguards. If we look at the next slide, I'll just hand over to Johannes to chip in, but you see essentially something very similar to what I've said. You see a couple of examples. Obviously, the names are clear, dates, fax numbers, social security numbers, all that is well known and easy to understand, but medical record numbers would qualify as well, as long as you're able to attract or attach the identity of a person to that individual. That is very wide. Johannes, do you have any additional remark on this one?
Yeah, no, that's it. And I absolutely agree with you that this is a slide that shows examples of PII, personal identifiable information, and protected health information, but the GDPR goes much further. And what you will probably talk about that later. You also need a much stricter type of consent if you record anything about anybody than just a "I agree" click on the website.
Let me just pause on that one, indeed, because one of the underlying principles of GDPR is that as soon as personal data is involved, there are the requirements of establishing a legal justification for processing that data, which could be consent, as you've just mentioned, as well as also other legal justifications, in particular the concept of legitimate interest, which is also set out in the GDPR. So that is important. Once you've opened the scope of the GDPR, you're looking at the reasons, the categories of data, and the purposes of processes and the related justification. If we flip to the next slide, I think, Johannes, that's something where you could already exemplify how that plays out into eDiscovery.
Yeah, because what we see on the one hand, and a lot of eDiscovery providers looking at that part of the equation first, are not aware of this, is that eDiscovery providers can be considered as data processors. This means that anybody who whose name or data is in this data set, you actually need to have full consent, written consent, and a very clear statement in advance that you are able to archive and process data from these individuals. And we've seen this, for instance, in the case of M&A, where there was a lot of real estate which had to be transferred and was refinanced. And part of this real estate transactions were mortgage agreements. And the mortgage brokers recorded a lot of information about the people obtaining the mortgages, about their religious, political, and other habits, which was done 10 or 15 years ago when these mortgages were issued. And they never asked consent. So before these contracts and this data could be disclosed in a data room, they first had to redact all of this information. Now, the other impact for eDiscovery providers is that under the GDPR, there's the so-called right to be forgotten. So in theory, every individual who has some kind of reference to him or her data in a eDiscovery investigation or a data room can request an eDiscovery vendor to actually remove that data. So that's one part of the balance, and this is just focused on eDiscovery processors and providers as data processors, but of course this also applies to any company, government, and other organization in the European Union. Only the problem with the eDiscovery providers is that they have tons of data from many of their clients, and this could in theory also apply to law firms who do eDiscovery in-house. On the other side, there's eDiscovery technology which can be very, very useful for GDPR compliance, because, for instance, if there has been a data breach, then under the GDPR, organizations must notify authorities and also inform data subject very, very quickly. And yeah, you can find out what has been leaked and who has been involved by using eDiscovery technology. Also, eDiscovery technology can be used to identify high-risk data, for instance, data containing personal information or healthcare information, which is stored on normal hard disks instead of encrypted hard disks. And this can be very beneficial for organizations to identify where risky data is. If you take it to the next slide, what we see as the practical implication of this is that in eDiscovery, before, for instance, suppose that you have a U.S. regulatory agency requesting information from which originates from Europe, that all of the personal identifiable information and all the other data protected under the GDPR has to be redacted before this data can be disclosed to such a regulatory agency, and this can be an awful lot of work. And it's not just redaction, it's also pseudonymization, and Alexander is going to talk a little bit more about it later. Now, in the field of M&A, if you have a virtual data room, you have to do the same. Before you can disclose data from a virtual data room on any corporate transaction, you have to do the same anonymization and pseudonymization, especially if you do an auction and you show this data to various parties outside of the European Union or even inside of the European Union. You have to go to this tremendous effort. And we've seen where this came as a total surprise to parties preparing a virtual data room. And then in the middle of the transaction, they found out it all had to be anonymized and pseudonymized. And then they had to, they started working with black markers and hundreds of people trying to anonymize everything. And this can be done much better, as I will show in a couple of slides. So next slide, please, and then I'll take it over back to you, Alexander.
Thanks, Johannes. And let's just pause on this concept of anonymous and pseudonymous data. Why do we actually need this? The overall concept under the GDPR is the principle of processing personal data guided by the principle of purpose limitation and necessity. So the idea is you're only allowed to process personal data unless you've procured explicit consent, but otherwise only to the extent it is needed and needful to comply with a legitimate purpose. which means when you're running an M&A transaction, the legitimate purpose may be, yes, you want to buy a company, but that does not necessarily imply you need to see every single data entry about a data subject, which is more or less, if you like, the victim or the third party not involved a data subject to this transaction. So the rights of the data subjects are strengthened in that sense. As Johannes, you already mentioned, the good way out of this is you're able to anonymize data. Now, what does anonymization mean? The heart and essence of this is it is very difficult to achieve. The European data protection authorities already 3 years back have issued an opinion about the requirements and thresholds for effective anonymization, and it means the irreversible deletion and removal of the personal identifiers, which means irreversible for everyone. So if you redact a copy and delete the names on the copy, this is maybe irreversible for that individual copy, but it's not entirely irreversible, which means it's not easy to talk about anonymous data effectively. Which has been recognized by the GDPR, and they've said, well, we need something in the middle, and we'll call it pseudonymization. Pseudonymization means, as you can see here in the middle column, the data can no longer be attributed to a data subject, but there is still additional information kept somewhere else which allows to re-identify the data subjects. And obviously that requires then a very different level of safeguarding, because you could say, as long as you're dealing with anonymous data, no problem. This is irrelevant for privacy law. Take a totally unrelated example to what we're discussing here. If you talk about raw machine data, sensor data, no personal identifiers contained, no applicability of the GDPR. If you're talking about redacted HR files and payroll information, you're talking mostly about pseudonymous data. And the GDPR has recognized that that's an important tool to flexibilize the use and run these processes which we're discussing today. So if we look at the next slide, we can show you a little bit the criteria. First of all, pseudonymous data continues to be a form of personal data. And the pseudonymization is typically conducted by the data subject itself or someone acting on its behalf. So you could say a user idea, which your system administrator is running for you, is an element of pseudonymous data. The system administrator has, if you like, the key to de-pseudonymize, to re-identify you as an individual. Now, if these means of pseudonymization are in the hands of a data controller, which could be the operator of an M&A transaction room, which could be the litigant in a dispute, which is running a large review of its own files, or you're running an eDiscovery and you're even in the position to look into the files of the other opponent party, you will have a data controller which is acting, and then it requires those safeguards which the GDPR sets forth. And it is to be said, the GDPR has been developed very well in many regards, but it has also left open space for further interpretation, and that applies in particular to the criteria for effective pseudonymization, which at the time the lawmakers sat together found, well, we're not the technical experts. We'll put the framework in place so that technical experts, under the guidance of the so-called EU Data Protection Board, which is more or less a representative body of the national data protection authorities, but which also has the competence and authority to issue guiding principles which are, if you like, effective at the level of law, that the EDPDB, as it is abbreviated, will be able to further specify the criteria for effective pseudonymization. If we look into the next slide, you get a little bit of a better feel where that all appears. If you're dealing with pseudonymous data, you're actually generating higher flexibility and dealing with processing personal data, pseudonymized data, for other purposes, similar purposes, I should say, and you can look that up in Article 6, Paragraph 4E of the GDPR. You can look at the relevance of pseudonymization also at the level of how you design technology. So privacy by design, you look at the use of pseudonymization technologies as a measure of technical security. So technical security is obviously a very fundamental constituent of the GDPR and something that Johannes has already alluded to, because wherever technology providers, including companies like ZyLAB, who are facilitating eDiscovery, as long as they're dealing with personal data, pseudonymous data, they need to make sure that they are operating in a data secure environment, and the technical requirements will include to provide for proper pseudonymization technologies. You also have other areas, codes of conduct, which will be developed by industry bodies, which will achieve legal recognition on what are relevant pseudonymization criteria. They could come up with relevant criteria for the operators of eDiscovery tools. So something to watch out as the law develops. If we look at the next slide, I'm just going back to the concept of anonymization. I've already explained it, but just to put it in front of our faces again, anonymous data is something where you can no longer identify the natural person. This is a very high threshold, and we all need to be fair to ourselves in times of big data. If you have 3 data points which are not the name, not the date of birth, but anything else, you will very easily be able to identify a person, an individual, and you're for sure able to do it if you have 4 data points, which on the face of things might appear unrelated. So bear in mind that we might be using colloquially the term anonymization. Effectively, under legal terms, it is not that easy. And if we look at the next slide, I've just summarized that out for you again. 3 criteria. Is it possible to single out an individual? Well, then you're not talking about anonymous data. Is it possible to link records relating to an individual? Can the information be inferred concerning an individual? All of that, that's what we know from big data, would kick out the reliance of anonymization of data, and then you're talking about pseudonymized data. So that's something that technologists are looking at, but for legal purposes, let's be honest, we're not always going to be operating within that very frame. Whereas if we flip to the next slide, I mentioned that encryption, next slide please, that encryption is a very important element in the framework of the GDPR, both in terms of achieving the effective pseudonymization as well as also managing technical security. So this is something that will reappear as a theme wherever you're dealing with technology suppliers. If you're running eDiscovery and you're using proper providers, the element of encryption is highly relevant. And it is something that will be the measurement point of quality and of quality standards for suppliers. Let me move on to the next slide, which I think is, next slide please, is very relevant.
Pardon the interruption. Pardon me,
Yeah.
this is Tom. I'm sorry, I've asked the technician to hold the switch. I have to give out a secret word. It's timed, I'm sorry. So secret word number 2 is eDiscovery. Secret word number 2 is eDiscovery. Please add that to your question, to your survey when you attendees when you're filling those out. And I would like to give a gentle time reminder to the speakers. We are 26 slides into it, and we have about we're about maybe 55% of the way in terms of our time, and we've got the better part of 31 slides so left to go. So I'd ask you to perhaps look at some slides and choose to maybe summarize some to get your points through, and perhaps leave some of the material that we have available as leave behind. We do have an extra half hour to go if we need it, but I just wanted to let you know so you can budget your time accordingly. Back to the speakers. Thank you.
Thank you, Tom. That's greatly appreciated. And indeed, the next slide, if we then do see it, is actually maybe the core element from a legal perspective if we're looking in particular into eDiscovery. So thanks, Tom, for raising that key point here. It's not only a secret word, but it's highly relevant in this context. You see a question mark behind GDPR as a blocking statute. Give me 1 minute to talk you through the idea and the concept. We have seen that U.S. courts have in the past looked with a great hesitance at data protection law in Europe when it comes to discovery requests, documentation production requests in U.S. court litigation, which may reach into Europe. They have often said in various degrees, well, how could a defendant claim data protection law as a pretext not to disclose documentation which is relevant to court proceedings in the U.S.? They would set aside data protection law, potentially at least, as a so-called blocking statute, and put the defendant in a very uncomfortable position in the U.S. court because he would be caught between a hard place and a rock between U.S. requirements and European law. This has led to solutions where the mitigating approach is that you actually redact that type of personal data which is not essentially needed for the court debate in the U.S., which then leads to those technology solutions which we are looking at today. We are yet to see how this plays out under the GDPR, but it is to be noted that the lawmakers of the GDPR have looked at this as a real issue and have found a solution which should allow to maintain control from a European perspective and at the same time allow data controllers to honor the requirements of U.S. courts. So whenever you are dealing with eDiscovery requirements driven by U.S. courts, this is the point in time to discuss with your lawyer whether and how you actually respond to that request, including involving technology solutions as discussed. Next slide, we'll go very fast through because what this tails on to, next slide please, is that data transfers, very briefly, from the EU outside into the United States or any other third-party country require additional safeguards on the recipient end, and those who've been following general newspapers will have noted that about a year and a half back, European Court of Justice brought down the safe harbor regime, which was one of those frameworks to allow data transfers into the U.S. We can see that here on the next slide, next slide please, which shows that at the time there was a problem when the safe harbor decision was brought down. It was replaced by the EU-US Privacy Shield, which again allows to transfer data seamlessly, if you like, from a data exporter in the EU onto a data importer in the United States. And if we look at the next slide, there are other transfer instruments which are also available, the so-called EU model clauses or standard contractual clauses, very often used within corporations to manage intercompany data flows with the deficiency that they ultimately are always bilateral agreements, and if you want to take something which I haven't put in the slides because it could take hours to discuss, binding corporate rules are the solution used to create a harmonized intercompany transfer data framework beyond the EU model clauses. With that, I think I'm almost through my part, so I'd love just to hand over to Johannes now, and might be chipping in one or the other thought as we go along.
Okay, yeah, thank you. Next slide, please. Thank you, Alexander, for a very clear explanation of the GDPR and the impact. And as you said, we will see how the law and the case law will develop over the next years. Well, one of the very important things that we have to realize is that it's impossible to do this type of work manually, not only the redaction of pseudonymization, but also all of the eDiscovery type of work, the sorting and the identification of data. And this is why we've been using analytics to better understand the data, reduce data volumes, and take a more investigative approach with the ultimate aim to reduce eDiscovery cost, improve productivity, better quality, speed up litigation, and effectively deal with GDPR. Now, if you take me to the next slide, please. I got a great picture here, and everybody who has seen the movie The Matrix will recognize Mr. Smith, who made the famous quote, "Never send a human to do a machine's job." And basically, eDiscovery is no longer a human job. The data volumes are so large, the requirements and the accuracy required by the courts is so high that we need machines in order to do this. Next slide, please. And there's a couple of reasons for this, because humans have cognitive limitations when processing large volumes. Humans get distracted. They take different decisions at different moments in time. Humans also are adaptive creatures, so we learn while we're doing things. So what we see is that humans are not only inconsistent, but often they are also inconsistent in their inconsistency, which makes it very hard to control and clean up whenever wrong decisions have made. There's a lot of scientific research, and I just quote to the research from Grossman and Cormack, which was done a couple of years ago, where it is shown over and over again that human beings are not very good in reviewing large document sets. Computers are better, multiple times, multiple factors better, often they're faster, and they're more reliable. So next slide, please. So I want to show you a couple of examples of what we can do with technology for a number of different tasks related to perception, reading, listening, but also understanding data in a structural way, understanding conceptual understanding of the data, and how we can use machine learning to teach a computer to do a certain job, and then the computer can repeat it. Next slide, please. And we can go very quickly through these slides and catch up a little bit in time here, Tom. This is a screenshot from our ZyLAB program where data has been anonymized. You can see that names have been replaced by numbers. And this is a fully automatic process where we use text mining tools to identify personal information or religious related words or political related words, and we can anonymize them or pseudonymize them automatically. This typically goes in a couple of cycles where we first do this with a standard set of libraries, then lawyers or other people review it, they see whatever words are not properly redacted, clean them up, and then typically we have to go to 6 or 7 of those cycles, and then we reach like 99% accuracy in redaction, which is then after that a fully automatic process, and you can still do sampling to test for the quality. Next slide, please. Now, PII is not only text-based, PII is also more and more image-based. So one of the other things we are working on right now in our R&D department is identifying IDs, passports, driver licenses, but also certain chats from WhatsApp or from Instagram, screenshots, legal type of documents where we're not looking at text, but we're really looking at kind of an image. And this will really help us to identify personal identifiable information stored in images in data set. Next slide. We can also use embedded machine translation, which will automatically translate, for instance, in this case, Chinese to English. It's not a legally submissible translation, but it's at least gives you an indication of what's in there. And it will also allow you to not only look at the content of the data, but also take some decisions of the data. Next slide, please. And what we do is that whatever kind of bitmap we find in the system, we will make it searchable through a combination of OCR technology and image recognition, image classification, where what we see a lot, and this is really investigative in nature, is that with WhatsApp, data is encrypted, but a lot of people that do certain type of things, especially in fraud investigations, they make screenshots or pictures of their WhatsApp appointments, and they keep copies of those, or they make screenshots of Instagram or a picture. Now, we've solved a lot of internal investigation cases by being able to detect and make these type of pictures searchable. Next slide, please. Now, one of the other things that we see a lot is that data is hidden, not by using encryption, but it's hidden by storing it as an embedded object in an email. You can store an email on a calendar item, or you can store it in a zip file, or you can store a TIFF, a non-searchable or non-searchable PDF file in a zip file, and then attach that to an email, which you then attach to a calendar item. or you can do an embedded object in a Word file. Now, what we do at ZyLAB is that we unpack everything and make everything searchable, so you can then use automatic tools to identify this type of data. Next slide, please. We go a little bit beyond structure. We also look at one-on-one communication, which is often the most interesting kind of communication in eDiscovery. If you really want to find out what happened, who was responsible for certain actions, you will often find the information in the one-on-one communication. And then if you take me to the next slide, please, you see that if there are very long email trails, then in these email trails, we can not only visualize them, as you can see here on the left side of the slide, but we can also show which emails in that trail are missing. This could be because you have not collected certain data from a certain custodian, and then this can help you to go back to your client, say, listen, I also need these and these custodians, or you go back to an eDiscovery and you look up those documents, and then you can see what was the full discussion. Okay, next slide, please. This is all structural in nature, so it's kind of the syntax of data. But more interesting is the conceptual nature of data, which we call semantics. And this does not only have to do with semantics, but also, for instance, with emotions and sentiments. And what we can do by using text mining technology is we can recognize these types of things. So without having to specify in advance what organizations are, companies, individual names, locations, or positive or negative emotions and sentiments, we can actually detect those with a very high reliability in the system, and then use that to organize the data in what we call facets, which are fully clickable and interactive. And I'll give you a link to where you can try this later yourself. And then you can take a look at this type of interaction with data is much easier. Next slide, please. Now, what you see here is the latest and greatest. What we have is, even if you don't know exactly what you're looking for, we use clustering, and we can organize and display result of data, both in a tree form on the left, but also in a word wheel, which is also fully clustered in our article, and gives you an indication of data. And this will help you to understand what's in the data set, even if you haven't searched at any word. It just gives you the main topics. We use topic modeling for this that are in the data set. Next slide, please. Okay, now this is part of a larger picture where where our effort is to organize data along the dimensions of typical investigation questions that we see in eDiscovery or in M&A, which is almost always around like the who, where, when, what, why, how much, by which means. And first part of this process is that we identify semantical categories like person, company, organization, and then we make different types of analysis and visualizations of those, as you can see here. And if you want to learn more about that, I'm more than happy to tell you, or you can download one of our ebooks that I will refer to at the end. Next slide, please. Now, where we see major traction right now is in using machine learning in order to teach computers what is of interest. And this is not only interesting for searching and finding responsive documents and really boost recall, but also to find privileged information, detect contract clauses, or redact and pseudonymize information under the GDPR. Because only by using machine learning you can get like the quality levels that are required under the new GDPR statutes. Next slide, please. Now, where this is coming from is from the world of predictive coding, where documents are automatically classified. This is an example of a large data set where 90% of all relevant documents are identified by just reviewing a small fraction of the documents. And you can read back on this on the ebook on artificial intelligence and technology-assisted review. What we've done, next slide please, is that we've taken this technology and we've also used this to do clause detection, which can be very beneficial for M&A. But the same technology can also be used for redacting, and for what we see is the most powerful application in the next slide is the machine learning using as the new search. Because what we see is that traditional keyword and Boolean search is very hard for users to use. Not every user knows what to use. They also really don't know what words to use, what to spell them. And the bigger problem is that you never really know how much data you've actually retrieved. And users often think that they retrieved 80%, and then when we run the tests, we see that they are closer to 20 to 40% than to 80%. Now, if you take me to the next slide, please. What we are able to do with this technology is that we are able to help users that are not very skilled searchers to reach unprecedented levels of recall. And instead of them having to master search, metadata search, advanced search, Boolean search, quorum search, processing tools, whatever, they can just do a very basic search and then use machine learning from the start. If you take me to the next slide, I got an example here of what we did recently, and we see exactly the same numbers in ratio of numbers in other cases. We were looking for documents related to credit agreements. We asked the lawyers and the reviewers to define different quotes and queries. Now, one of the problems with Boolean search is either feast or it's famine. You get too much or too little. And which we explained in the first part of this slide. Now, what we found is that the lawyers eventually, after weeks of review, found 300 documents, and they were very confident they found everything. We then use these 300 documents to teach the computer a profile, and we actually found 345 relevant documents to which the lawyers agreed. We see that consistently we find 15 to 50% more relevant documents than human beings do. Now, next slide. We can very accurately calculate the recall and the percentage of what we find. Now, this is very useful if you have to convince a regulator that you have actually found 80% of all the relevant documents. And if you take me to the next slide, the way how we do that is by measuring the the precision of the return set. And what we do here is we teach the computer to find certain documents. You see that the precision goes very quickly to 100%, but at a certain moment there are not enough relevant documents to return, and that's where you see the number of the precision going down until it reaches like 0%, and then each dot is a machine learning cycle. At the end, we find no relevant documents anymore, and then you know pretty much for sure that you have found like everything or almost everything, like 99% of what's relevant. Next slide, please. Now, we can do this in a very short time. It's not only better, but we can also do this 15 to 20 times faster than with manual review. And we use exactly the same technology for pseudonymization and redaction that we use for searching and classification of documents with the technology-assisted review. Next slide, please.
Quick interruption. Sorry, this is Tom. I want to just give out the third secret word. I have to do it before the credit hour is up. Third secret word is data. D-A-T-A, secret word number 3. Back to you.
Okay, thank you. Can I continue?
Please go ahead.
Yeah, okay. So, yeah, the benefits for in-house counsel. Well, first of all, identify where PII is stored, deal with it, encrypt it, anonymize it, pseudonymize it, effectively deal with cyber events. And this is really a major improvement over doing this type of work manually. Same with eDiscovery, direct collection. You don't have to mess around with hard disks. Deprocessing, make everything searchable, turn as little data as possible over to the other party without getting in trouble. Use review accelerators, dealing with the most expensive part of the eDiscovery process, and use early case assessment to develop a strategy early in the process of the investigation, litigation, or regulatory requests you have to deal with. Next slide, please. For law firms, there are many examples, which I just list a couple of them here. One of the things we have is that law firms can themselves upload data and almost immediately start reviewing. You will find out what happens by using our deep analytics, and then really work. If you need a larger review team, you have more than enough arguments to do so. You're more competitive, and we even see law firms replacing traditional interns at the bottom of the earnings pyramid by what we call review robots. And in the United States, we even see more and more law firms hiring data scientists helping the law firms. And I'm sure you see similar things, Alexander.
Yes, that's right. Obviously, it's important to know that the legal system in the U.S. is, if you like, more prone to document production in general, and particularly the eDiscovery process is obviously something that does not necessarily exist to the same extent in continental European jurisdictions. But if you just simply look at the M&A side of things and the large need for crunching data or documents and extrapolating data, then you're absolutely in the same ballpark.
Yeah. Okay. Now, next slide, please. If you want to try this out, seeing is believing, go to our website, www.zylab.com, and sign up for a free demo. You can try it yourself. We give you, you have to just register, and we'll get you a login account. And then you can search in the entire Enron data set or in a very large M&A type of data room that we've set up. Next slide, please. We have many very happy users, and we try to keep technology simple and understandable. So our first objective is to provide lawyers trust with technology and make it also defensible. If you want to learn more about defensibility, next slide, please, then you can also go to our website. There's a lot of ebooks, and there's also, we have a trust center where you can download a full paper on explaining how this type of technology has also been used by war crimes tribunals for Yugoslavia, Rwanda, Cambodia, and a lot of other high-stake organizations, and how they have dealt by using this type of technology and also make it dispensable for all parties. Next slide, please. Okay, you want to add something here, Alexander?
In very brief terms, I think it's just to say that we are seeing an increasingly tangible dynamic for general counsel, so the heads of our legal departments at our clients, looking at artificial intelligence, trying to develop an understanding for the practically useful tools that can help them manage workflows in specific areas. So if you talk about AI in the legal profession, it's not necessarily saying everything will be wiped out. It's really trying to enhance processes. I think we've seen very good examples, as you've demonstrated here, Johannes, today. And it's not just about keeping an eye open. What we find most useful is really trying things out in a clearly predefined ambit and making it work and happen. And we see huge benefits because if we look at how we serve our clients best, it's really trying to get the pain off the mind of our general counsel contacts, how they can enhance the work that they need to do and make it more efficient, more interesting, and they can get rid of the work that is not manageable in terms of numbers, in terms of scale, in terms of attention, in terms of precision, which can then be handed over to those types of services as we've been discussing today.
Yeah. Okay. That's it for us. Any questions, Tom?
We do. Thank you, gentlemen, for joining us today. You got through an incredible amount of information in a relatively short period of time. I commend you on your skills and being able to do all that. That's not easy for those who haven't had to do that. So thank you. It's a terrific presentation. You know, this kind of stuff is going to change the way we work on many levels. Artificial intelligence data, as you both indicated, is, too big now in some respects, particularly in eDiscovery. It's going beyond what a human being could actually sift through in a meaningful time frame, in a meaningful way to have any impact on cases that lawyers are working on. So very interesting. So we do have a couple of questions. We have a little bit of time. We'll run over about 5 minutes, so I'll get through just a few of these if we can. It says, one of them is a company required to renew the client customer permission to access data annually?
So I might pick that up. So the customer-client permission, if you're looking at it from a data protection perspective, you're talking about the validity of consent And the requirements on consent under the GDPR are that you need unambiguous, freely given consent. It may be that some of the consent declarations given in the past do not meet those requirements. We've had different variances in the member states of what consent needs to look like, and the advice would be you probably need to revisit your database of consent, your repository of consent, and qualify which of those may need to be renovated. However, it is not a need to go through an annual review. It is just this steps change towards the GDPR, and then the guiding principle is you can process data based on consent within the scope of consent. So within the boundaries of the consent, anything that's outside is not justified by consent, and that's where you ask your lawyer whether there are other legal bases which would allow you to do so.
All right, great. Let's go through these kinds of quickly. So the next question, thank you. That's a great response. When considering third parties, what about the contract? Does the contract between the company and the third party suffice an agreement by the client for access to data? So is that the contract is actually the data access, the agreement that governs access to the data?
So I'll pick that up briefly, and Johannes, you obviously feel free to chip in.
No, this is all your stuff. Yep. This is your specialty.
Very good. So what we're looking at is if you're engaging a service supplier, the service supplier, such as ZyLAB, would be in legal terms a data processor, which is acting under the instructions of the data controller, which is essentially the customer, and the customer takes charge and is directly liable for data protection compliance. What the customer will do in the contract with ZyLAB or any other provider is enter into a so-called data processing agreement. And that is then laid out and defines the rapport also in terms of data protection compliance, and you're done. So it's a necessary element from the toolbox you need to add.
Okay, good. A couple more quick questions here. What are the capabilities with regard to audio and video data? Do we have an ability to incorporate chronologically with other data to sync these up?
Yeah, that's a very good question. Well, with audio, there are many what we've been integrating in our products for a long time. I haven't emphasized it here. Is the ability to search in audio. We can do that in many different languages. We use phonetic search, which works very well. With respect to video, we can already search the audio component of video files. With respect to the video content, the image content, that's a little bit harder. We are working very hard, and we should have this in our platform probably somewhere next year, where we can tag video content and images with textual information, and then recognize objects and what's happening in the video or in the images, and use that then for the discovery process.
Great, thank you. And then the final question we'll ask today is, what about languages? Does the program or service have the ability to discern the nuances of other languages? Or what are
yeah, that's a very good question. Well, the languages are automatically recognized by the system. We support hundreds of languages. We can search and full text index hundreds of languages. With respect to the higher cognitive levels, machine translation, audio search, we do not have support for hundreds of languages, but we do have support for most of the Western European and other Asian and Middle East languages. And if you are interested, just send us an email. We provide you with lists of languages that are supported. But what we try to do is we try to develop this type of technology being as little language dependent as possible. And yes, we do teach the systems by using large data sets, the capabilities of semantic analysis for other languages as much as we can automatically.
Okay, that makes a lot of sense. Thank you for that. Good. All right, excellent. So that's the business on the language. and reach out directly to ZyLAB for questions about that and lists and things of that sort. Well, that's about all the time we're going to have today to talk about artificial intelligence and eDiscovery. This is very fascinating technology. We had presenting today, we had Johannes Scholtes. He's the Chairman and Chief Strategy Officer over at ZyLAB. His contact information is present in this material as well, so if you're interested in finding out more about this terrific solution they offer, you're welcome to reach out to them directly. We also had Dr. Alexander Duisberg. He's a partner over at Bird&Bird, and he contributed significantly to today's presentation as well. We would like to thank both of you for participating, as well as our speakers. A couple of final announcements that need to be made before we go. If you are requesting a certificate of attendance for CLE credit, you have to fill in those secret words that we gave out into your surveys for today's webcast. If you haven't received that survey, please send an email to info@theknowledgegroup.org. We also like to thank our attendees as well, speaking of them, for carving out time out of their busy schedules and help making this event a very successful one. For those of you who wish to receive updates about this event, as well as other Knowledge Group events, please follow us on Twitter. We're at @no_group, and you're going to receive all the relevant updates you need for this event, as well as some of the exciting things that we have coming up. Ladies and gentlemen, this does conclude our event. It was called Artificial Intelligence and eDiscovery, a Productivity Revolution for Data Collection, Processing, Review, and Production. It was a live webcast, and the content truly highlighted the revolutionary nature of this new service. If you have any questions for any of our speakers, go ahead and send an email directly to them. We sent you their contact info and the course materials for this event. If you don't have that, the magic email is info@theknowledgegroup.org. Contact the Knowledge Group using that email, and we'll put you in touch with anyone, and we'll provide you with any materials that you may or may not have regarding this event.